Thank you, thank you. Thank you, Sir Mariano. Thank you, thank you. Okay, na ba dyan, Sir Mariano? Okay. Thank you. Sir Mariano was our student. Yeah, he is a graduate of USSD colleges way back 2011, isn't it, sir? Yes, 2011, and he took the licensure examination about September 2011. And when the result of the licensure examination came out, the result is 0.15 difference, lower than number 10 nationwide. So we tried to negotiate it with PRC, but PRC is firm with the decision that 0.01 difference is really matters. Okay, so nasa akin na ba ang floor, Sir Mariano? Okay, so okay. Thank you, Sir Pasag, Sir Mariano, and other faculty members and students of Pan Pacific University. And of course, there are some students of other colleges like OSHA's College, okay, who were invited to join under the advisorship of Ma'am Bumagat. So we are very thankful for the cooperation of OSHA's College, and of course, we are very thankful for the initiative of Pan Pacific University because this is the second time that I will be delivering this seminar, latest trends in criminology with the Republic Act 11131, because the first time was just last Tuesday. I was asked by Dean Pumacha of University of the Cordilleras to discuss the same to his graduating students. And out of the 44 graduating students, 41 or 42 joined. Okay, so almost all joined, but it was explained by Dean Pumacha that the one or two who did not join had a problem in connection. So it is better, Sir Pasag, if you are going to make some research on how to enrich the connection so that all will be joining. No? So thank you. Okay, so to start, paano dumami yan? Entire screen, no? Ayun. Okay. So, in other schools or in other public speaking venues, they are just calling it Seminar in Republic Act 11131. But I think this is the best title that must be given to this seminar. It must be the latest trends in criminology profession with Republic Act 11131, because Republic Act 11131 is only a part of it. It is only a part of it. So you may ask, how come that it is only a part of it? We are going to discuss it as we go along. So this will be our topics. So first is we will be discussing an overview on criminology, so that we will be having an idea on what is the criminology profession is. Afterwards, we will be discussing the licensure examination for criminologists and the practice of criminology, the privileges of criminologists as provided under Republic Act 11131 and other laws. And we will be discussing also some laws in relation to criminology, in relation to the CHED, PRC, PRB, or the Professional Regulatory Board for Criminology, the CPD Council, and others. Next is we will be discussing the curriculum, little bit extensively. We will be discussing the distinctions between CHED Memorandum Order number 21, series of 2005, and CHED Memorandum Order number 5, series of 2018. And next is we will be, okay, sorry. Okay, so this is the definition of criminology under Republic Act 11131. We are referring to the study of crimes, criminals, and victims. If you are going to observe, there are several subjects intended for crimes and criminals. But I'm just wondering, under Chen Memorandum Order number 21, series of 2005, and Chen Memorandum Order number 5, series of 2018, there is no specific subject dealing with victims. So perhaps in the future, or in the colleges that are autonomous, our best suggestion is for them to incorporate some subjects that are intended for the study of victims. Isn't it? It is one of the issues at present in relation to the participation of victims in the commission of crime, especially that the Cuneta and Pangilinan family is involved in this issue. This is the definition of a criminologist. So for a person to become a criminologist, he must comply with this. First, he must finish Bachelor of Science in Criminology. And second, he must take the licensure examination for criminology and, of course, will pass it. And the third requirement is he must be registered as criminologist before the Professional Regulatory Board of Criminology. You may ask, what if a person will be finishing Bachelor of Science in Criminology, took the licensure examination, and while waiting for the result of the licensure examination, that person died? So can that person be considered as criminologist? To tell you, no. Because to be registered as criminologist in the Professional Regulatory Board of Criminology is a mandatory requirement. And that law or that policy is not applicable only to the criminology profession. It is applicable to any other profession. Like, for example, for a person to become a lawyer, the last step for a person to become a lawyer is he must sign in the role of attorneys before the Supreme Court. So there was an actual case wherein a person finished Bachelor of Laws, he took the bar examination, and while waiting for the result of the bar examination, he met an accident. And he died as a consequence. So the family members of that person asked the Supreme Court that it is possible for the title attorney to be placed in his name, sa lapida. But the Supreme Court said no, because he did not comply with the last requirement, which is the affixing of his signature and name in the role of attorneys. So, but there is another way how a person may become a criminologist without finishing Bachelor of Science in Criminology, and that is by virtue of the qualifications upgrading program of the NACOLCOM. If you still remember our discussion in the subject police organization and administration, Republic Act 8551 became effective way back 1998. It is the policy of the government that as much as possible, all policemen must finish their degree courses. So there must be a way for them, or means for them to finish their degree courses, but not in a manner that an ordinary college will finish it. So this is what we call the qualifications upgrading program. So the National Police Commission coordinated with the DEX. Okay, before we are calling it DEX, the Department of Education, Culture, and Sports. I'm very sure that Dean Pasag, naabutan niya itong DEX na ito. Because naabutan ko to when I was in elementary, the department that is handling our education system was DEX, but afterwards it was subdivided. Okay, the elementary and high school level was placed under Deferred. The four-year courses were placed under the authority of CHED, the Commission on Higher Education, and the short courses was placed under TESDA. So, as a result of this coordination by the National Police Commission with CHED, the ITIA program, or the Expanded Tertiary Education Equivalency and Accreditation program, was introduced. So the policeman can finish their criminology course in a simplified manner by enrolling in the ITIA program. In the Cordilleras, the school that is offering ITIA program is the University of Baguio. In Region 3, it is Oroyo University. I do not know if what school is offering ITIA program in other regions. So let's go to licensure examination. What are the qualifications of a person to take the licensure examination for criminologist? So first is, he must be a citizen of the Philippines. So you may ask, what if that person is not a natural-born citizen? He is a naturalized citizen. Can he still be allowed to take the licensure examination for criminologists? I'll tell you, yes, because our law states that it states for a mere citizenship. It did not expressly provide for a natural-born citizen. Under the Constitution, there are two classifications of citizenship. We have the natural-born citizen, and we have the naturalized citizen. The natural-born citizens are those citizens of the Philippines from birth, but the naturalized citizen are those who must perform an act in order to acquire or perfect Philippine citizenship. So you may ask again, what if a person is a foreigner and he does not want to be naturalized? Can he take the licensure examination for criminologists here in the Philippines? I'll tell you, yes, because that is what is provided in the second phrase of letter A that we are discussing at present. So, foreign citizen may take the examination here in the Philippines if there is reciprocity in his own country or in his national law. The reciprocity means that we are giving some privileges to the foreigners, provided that in the national law of those foreigners, Filipinos are also enjoying those rights and benefits. Okay? So, another qualification is that person who must be taking the licensure examination must be a person of good moral character. So, you, especially graduating students, huwag na huwag ninyong aawayin ang mga deans ninyo. Kaibigan ninyo ang mga deans ninyo. Why? Because one of the requirements for you to take the licensure examination later on is the good moral character coming from your dean. You may ask, sir, the good moral character is being issued by SAO, the Student Affairs Office, or SAS, the Student Affairs Services. To tell you, there was an instance last year, I remember, wherein the PRC did not accept the certificate of good moral character coming from Student Affairs Services. The PRC little bit became firm with a policy that the good moral character certificate must be coming from the dean, which is correct. Ganyan dapat. Why? Because your dean knows your character. So it is just and proper that he must be the one who must certify as to your character, if it is good or bad. So you may ask again, why is it that in our law, what is provided to be produced by an examinee is certificate of good moral character coming from the school where he had graduated, and good moral character coming from the barangay, and there is no provision as to the good moral character coming from the parish or church. To tell you, perhaps because it is already a culture of PRC that they are requiring the good moral character certificate coming from parish as a requirement for you to take the licensure examination. But I do not know in their specific rules if there is an express provision for such. But as long as licensure examination for criminologists is concerned, you must prepare for good moral character coming from three entities. First, coming from the school where you have graduated. Second, coming from the barangay where you are residing. And third is coming from the church where you are a member of the congregation. A person to take the licensure examination for criminologists must also finish his criminology in an accredited school of criminology. So do not worry, because all of our schools here, Pan Pacific University, OSHAS, and other schools, do not worry, all of them are accredited. Because before a criminology school will be allowed to have its graduate, they must undergo 2 inspections coming from CHED. The first inspection is for the purpose of initial permit to operate, for them to open criminology, and it is indicated therein if what are the year levels that must be open, if it is for the first year or second year only, or up to the 4th year level. And before they will be allowed to have a graduate, another inspection from CHED will be conducted for the issuance of recognition. And CHED is doing so by sending its RPAT members, the Regional Quality Assessment Team members. In Region 3, I have with me Sir Mariano, my companion, as an RPAT member in the region. So we are inspecting criminology schools here in Region 3, together with other RPAT members like Dr. Jester Eduardo of NUST, Dr. Bayani Salamanca of Orollio University, Dr. Hipolito of Angeles University Foundation, and others. Okay? We are the RPAT members being sent by CHED here in Region 3 in order to do the inspection. So next is must not have been convicted of an offense involving moral turpitude. So iwasan natin, no? Iwasan natin ang mag-involve sa krimen. And letter E is those who have failed 5 times, whether consecutive or cumulative, in the licensure examination, they must present a certification that they have finished the refresher course. So you may ask, what school is offering this refresher course? How can we get this refresher course? My friend is already taking the licensure examination for the 10th time. Is he required to take the refresher course? Okay? So we will be going to the first query. Where are we going to take this refresher course and how? To tell you, we do not know yet. We do not know yet because Republic Act 11131 became effective way back November 2018. So another query is, my friend is taking the licensure examination for 10 times already. Is there a need for him to obtain a refresher course? To tell you, not yet needed. Because the start of counting of these times to who failed the licensure examination must start in June of 2019. It must start on June of 2019. That is the first counting. To cut this story short, all the previous failures before the June 2019 licensure examination, walang bilang yun. Also, the counting will be starting on June 2019 criminologist licensure examination. So, in summary, what is the distinction between Republic Act 6506 and Republic Act 11131? So first is what I have discussed with you a while back in relation to reciprocity, wherein we are giving some benefits to foreigners here in the Philippines, provided that they are going to provide same benefits or rights to Filipinos in their own national law. Okay, so that is what we call reciprocity. Don't you know that under Republic Act 6506, it provides there that if a person finished Bachelor of Laws from the effectivity of this law, that is Republic Act 6506, if he finished Bachelor of Laws, he is required to take 94 units in criminology, and afterwards, he can take the licensure examination. But to tell you, this provision of Republic Act 6506 was deleted. It was removed by Republic Act 11131. Next is, with respect to the refresher course, under Republic Act 6506, there is no such thing as refresher course. If a graduate will be taking the licensure examination for 10 times, 20 times, no problem. But under Republic Act 11131, if a person failed 5 times, whether consecutive or cumulative, he must satisfactorily complete a refresher course. Next is, with respect to the term deferred, under Republic Act 6506, there is no such thing as deferred, but the term deferred was introduced by Republic Act 11131 for the first time, and we will be discussing this terminology later on. Okay, let's go to licensure examination. The original policy for a person to pass the licensure examination for criminologist, he must have a general weighted average of at least 75% with no rate of less than 50% in any of the 6 areas. We all know the 6 areas of criminology. We have the criminal law and jurisprudence, which is 20%. We have the law enforcement administration, which is also 20%. We have the criminalistics, which is also 20%. And we have the CDI, the crime detection and investigation, which is 15%. And we have the criminal sociology, which is another 15%. And last is correctional administration, which is 10%. So for a person to pass the licensure examination, he must get or obtain a rate of at least 75%, and no one of the 6 areas will be below 50%. That is the old or the original policy. The only distinction that was introduced by Republic Act 11131 is it increased the original 50% to 60%. So for a person to pass the licensure examination, he must obtain at least 75% general weighted average, and no one of the 6 areas must be below 60%. So this is a new policy. Paano na tayo nagkakaroon ng deferred? How can the term deferred comes into play? The term deferred will come into play if an examinee will obtain a general weighted average of at least 75%, but 1 or 2 of the 6 areas is less than 60%. So that is deferred. So to illustrate, we have this sample computation. What if an examinee will be obtaining this result? 89% in LEA, 89% in criminal jurisprudence, criminalistics, sociology, and CDI. But in correctional administration, it is 59%. The general weighted average, 86%. Under the old law, pasadong-pasado ito. No question. Under the old law. Baka pwede pa siyang mag-top. No? Under the old law. But under the new law, this is what we call deferred. Deferred because one of the areas is below 60%, but the general weighted average is at least 75%. So what is the remedy of an examinee whose result of the licensure examination is deferred? So under Republic Act 11131, he is given 2 years to retake the area. Only the 1 or 2 areas wherein he was deferred, and he must obtain at least 80% in that 1 or in 2 areas. So we will be going again to sample computation. Before going to sample computation, I'm very sorry. What if the result of the licensure examination is at least 75%, but 3 or more of the areas is below 60? To tell you, that is failure. Okay, that is failure because deferred is applicable only if the area that fell below 60% is 1 or 2 areas. If there are 3 or more areas, that is already failure. So we are going to summarize how may an examinee fail in the criminologist licensure examination. So you may ask, sir, di ba dapat ang discussion mo ay how may an examinee pass in the licensure examination, hindi yung how may an examinee fail. But to tell you, if you will be determining how may an examinee fail, then automatically you also learn how may an examinee pass, isn't it? So, first, under the old policy and new policy, an examinee will fail in the licensure examination if the general weighted average is less than 75%. Okay, so that is there is no problem with this provision because it is provided under the old policy and new policy. Second is, if an examinee will be obtaining a weighted average of at least 75%, but fails in 3 or more areas. As I told you a while back, failure if below 60%. So if he will be failing in 3 or more areas, failure, even if he has a general weighted average of at least 75%. Let's go to the sample computation. In law enforcement administration, criminal jurisprudence and criminalistics, the examinee obtained 89%. But in crim social, crime detection, and correctional administration, he obtained 59% each, with a general weighted average of 77%. Under the old policy, passed. Okay? The sample computation is passed. But under the new policy, that is failure. Failure because 3 or more of the areas fell below 60%. Third, if an examinee will obtain a general weighted average of at least 75%, but failed 1 or 2 areas, so it means deferred, but did not take the examination within 2 years. So that deferred result will be converted into failure. Fourth, if an examinee will obtain a general weighted average of more than 75%, but failed 1 or 2 areas, took the examination within 2 years, but he did not obtain at least 80% in all of the deferred areas. Okay, so this is better illustrated by considering this computation. In LEA, jurisprudence, criminalistics, criminal sociology, he obtained 89%. But in CDI and correctional administration, he obtained 59%. So this is deferred, okay? Because the general weighted average is 81.5, at least 75%. So this is deferred. The law provides that he must repeat the areas wherein he failed, and that is the CDI and the correctional administration. By the way, as a matter of correction, I'm asking for apology. That must be crime detection and investigation. Okay, that must be crime detection and investigation. I don't know kung bakit na-encode na criminal yan. Perhaps dahil sa taas ay nandiyan ang criminal jurisprudence, criminal sociology, na-influensyahan na ako na ilagay na criminal din yun. But under our CMO, the proper designation of CDI is crime detection and investigation. Okay? So if he will be what if he will be repeating the subjects or the areas wherein he was deferred, and this is the result. In crime detection and investigation, he obtained or she obtained 89. In correctional administration, 74. If we are going to consider the mean or the average, it is 84. So, is this considered passed, failed, or deferred? To tell you, failure already. There is no such thing as deferred for the second time. No? It is failure. You may ask, but the mean or the general weighted average is 84%. That mean or general weighted average will not be taken into consideration. The one that must be taken into consideration is the original result of the subjects na inulit niya pagkatapos niyang inulit. Okay? The result of the licensure examination when he repeated it because he was deferred. So the 84% will not be taken into consideration. It will not be taken into consideration. So I repeat, this is failure. Let's go to the practice of criminology. We will be again distinguishing Republic Act 6506 and Republic Act 11131. What are the important provisions of Republic Act 6506 in relation to practice of criminology? So, a person is deemed to be engaged in practice of criminology if he holds himself out to the public in any of the following capacities. Take note of this. Okay? The first practice of criminology under 6506 is as a professor or instructor. So, when I applied after passing the licensure examination and I experienced how to teach in the college, of course, teaching major subjects in criminology. Some of my friends or some of my relatives are asking me, ano, tapos ka ng criminology, tapos naging teacher ka lang, hindi ka naging police? To tell you, this is now the time to correct that or to rectify yung pag-iisip ng mga tao na ganoon. Because under Republic Act 6506, to become teacher of criminology is the #1 practice of criminology. To become policeman and to become others are only secondaries. Practice of criminology. So this is the provision of 6506 in relation to practice of criminology. Yun. How about the provisions of Republic Act 11131? Republic Act 11131 categorized the practice of criminology into two. We have the natural persons and we have the juridical persons. We all know that the natural person refers to human beings, wherein the personality of a human being will start from birth and it will end upon death. So, for a person to be involved in practice of criminology, he must be duly registered criminologist and holders of valid certificate of registration, yung ID natin, that was issued by the PRC. The second paragraph referring to natural persons refers to foreigners who are given temporary or special permits to practice criminology here in the Philippines. How about a juridical person? We are talking about proprietorship, partnership, corporation, association. So they can be also involved in practice of criminology, provided that if it is a proprietorship, the owner of which must be a registered criminologist. We all know that there are some review centers who are catering review of licensure examination for criminologists, but the owners are not criminologists. So how can we deal with these juridical persons? To tell you, under Republic Act 11131, there is no direct or express definition of juridical person practicing criminology. So, baka yan ang palusot nila. Baka ang palusot nila ay, look, at Republic Act 11131, there is no definition of practice of criminology by juridical persons. So even if I am not a criminologist, I can establish a review center to cater criminologist licensure examination. It is true that Republic Act 11131 does not provide for it, but it is provided by common sense. Common sense dictates that if you are going to be involved in a review for criminology, then you must be a criminologist in the first place. Because how can you give something that you do not have? Isn't it? How about the partnership and others? How can, or what is the requirement for them to be involved in practice of criminology? So the partnership must be, of course, registered before the Securities and Exchange Commission. So this is the distinction between proprietorship and partnership. In proprietorship, only one owner, but in partnership, two or more. In proprietorship, the registration before the DTI is sufficient, but in partnership, there must be registration before the DTI and at the same time SEC, the Securities and Exchange Commission. So majority of the partners must be registered criminologists. So that if it is a corporation involved in practice of criminology, then the officers and board of directors must, all of them must be registered criminologists. Together, if it is an association or cooperative. So, under Republic Act 11131, these juridical persons must be registered before the board. We are talking about the Professional Regulatory Board of Criminology, which is under PRC. But to tell you, if I will be asked, how will this juridical person will be registered before the board? To tell you, for the meantime, I do not know. We will be waiting perhaps for the PRB, or the Professional Regulatory Board of Criminologists, to issue a memorandum for us to be guided on how will these juridical persons practicing criminology be registered before the PRB for criminology. So what are the privileges of registered criminologists under Republic Act 11131? So first of the privileges is criminologists are qualified to occupy any of the following positions, either in the government or in the private institutions. So these are the positions. We are talking about as a dactylographer, ballistician, question document examiner, forensic photographer, polygraph examiner, probation officer, parole officers, etc. So these are the positions that may be occupied by criminologists. To tell you, they are 25 in number. So, under number 25, a criminologist is qualified up to the rank of superintendent. So, there is no need for us, for a criminologist, to take a qualifying examination up to the rank of superintendent. But because there are several criminologists in the bureaus, and it is very impossible for all of those criminologists to be promoted, they must be taking up the competitive examination. So the highest of those competitive examination will, as a rule, be the one to be promoted. But theoretically speaking, all of them are qualified. It only happened that it is very impractical for all of them to be promoted. These are the different offices or the different agencies of the government wherein criminologists may be employed. So don't you know that there is a history of criminology profession? When the course BS Criminology was introduced, ang sinasabi ng mga tao ay, pagpupulis yan. So, way back 1990s, I witnessed, nakita ko mismo yung uniform ng OGT criminology students, wherein what is stated in their patch is police intern. Unlike at present that it is criminology intern. Why is it that it is criminology intern and not police intern? Because before, ang alam lang natin sa criminology, what we know about criminology is pagpupulis lang. But it was realized it is not limited to PNP. We are employable to the tri-bureaus and even EFP. But after the effectivity of Republic Act 11131, almost all agencies are already opening their arms, they are opening their offices for criminologists to enter therein. So, what are these agencies? Okay, Commission on Human Rights, Ombudsman, CAMELEC, DANR, CHED. So you may ask, how may a person enter in the agency of CHED, considering that the profession is little bit not connected with each other? To tell you, we have supervisors of CHED, and they are criminologists. Our supervisors of CHED are criminologists, but in other regions, the supervisors are not yet criminologists. Perhaps there is a transition from non-criminologists to criminologists. And Supreme Courts, we have the PIDEA, we have the PAO, and number 38, other government agencies. So in other words, a criminologist may apply in any of these 38 government agencies for him to practice his profession. So, to summarize, what is now the distinction, or what are now the distinctions between Republic Act 6506 and Republic Act 11131 as to the practice of criminology? So number one, we cannot deny that the scope of practice of criminology under Republic Act 11131 was expanded. So from few definition of practice of criminology, we expanded it even in agencies. And next is, there is an express exemption of criminologists in qualifying and entrance examination in different agencies. So we have a graduates and already passed the licensure examination who applied at AFP. When they came to our office, they said that they were exempted in the entrance examination of AFP. So next is the long and complicated debated issue in the qualifications of teachers of criminology was clarified by Republic Act 11131. So you may ask, what is this issue that you are talking about? Before going to the issue, we must first understanding what is this issue all about. Under the checklist of RQAT that we are using in inspecting criminology schools, and under the existing CMOs or CHED memorandum orders, wherein the checklist was based, the checklist provided for the qualifications of administrators. And the first that is provided with his qualification is the dean. So this is his qualification. So a doctor of criminology and other allied courses, etc. The chairperson has this qualification, wherein he must be a masteral holder in criminology and others. And faculty has also this qualification, wherein he must be a masteral degree in criminology and others. You may ask, why is it that our teacher is not yet Master of Science in Criminology? He is a fresh graduate of BS Criminology. To tell you, pinagbibigyan yan. Pinagbibigyan yan. The non-masteral holder are allowed to teach in the college provided they are going to sign an undertaking, an affidavit of undertaking, that they must finish their Master of Science in Criminology as soon as possible. In the state universities and colleges, like us, Tarlac State University, a non-holder of masterals can teach, but they cannot be given a permanent item. So, how about the technical subjects? Like, for example, criminalistic subjects. So, under the CHED memorandum order or the checklist that we are using in inspecting criminology schools, the teachers of criminalistic subjects must have undergone training in those fields. Okay, so that is what is provided by the checklist. And this is the last provision of the checklist that I am going to present to you, wherein the faculty for, it is stated here that the faculty for major subjects must be at least master's degree in criminology, registered professional, and practitioner. This very, very simple term, practitioner, placed our situation in the academy in a very big situation. Because there are several policemen who are not criminologists. They are edu graduates, business courses graduates. They are not criminologists, but they are policemen, and they are insisting for them to teach major subjects in criminology. So, to cut this story short, the main issue that I'm talking about is, may a policeman who is not criminologist allowed to teach major subjects in criminology because he is a practitioner. Why practitioner? Because he is a policeman. So to tell you, this was clarified by Republic Act 11131. According to Section 16 of Republic Act 11131, all subjects for licensure examination shall be taught by a registered criminologist. So, tapos na ang boxing. It was already clarified that those are not qualified to teach major subjects in criminology. How about law subjects? No problem with law subjects. The qualification is as long as he is a lawyer. Or in the latest CMO that we have, at least he is a graduate of college or Bachelor of Laws. What are the privileges of criminologists under the other laws? It's still in Republic Act 11131. So, a registered criminologist is eligible to become inspector, given a rank of inspector in the police, fire, and jail bureaus. And its equivalent in the PDEA, the Philippine Drug Enforcement Agency, NBI, and other law enforcement agencies. Provided that they are criminologists and they possess the general qualifications for appointment of police officers, BGMP officer, BFP officer, PDEA, or NBI officers. So that is the requirement or qualification. Provided, however, that those who are already in the service must be prioritized. They must be given preference. So if a person just passed the licensure examination for criminologists and entered the PNP, he must not expect for him to be given a rank of inspector agad-agad or immediately, because there are some criminologists who are already in that bureau. So under the law, they must be prioritized. Those who are already in that bureau are prioritized. So those who will be just entering will be second priorities to be given a rank of inspector. This is the original policy of lateral entry that is being enjoyed by criminologists. So this is provided by Republic Act 6975, wherein, according to Republic Act 6975, if a person is a criminologist, then he may be appointed to the rank of inspector to fill up the vacancy. So do not forget the phrase, only if there is a vacancy, because it is impossible for all policemen to be appointed for that position of inspector. So if you are going to observe, under Republic Act 6975, criminologists qualified to become inspector in case of vacancy in the PNP. But at present, not only in the PNP, it includes, I repeat, PDEA, NBI, fire, jail, and other law enforcement agencies. So, another qualification of a person to become, if he is a criminologist, is he is qualified to become a policeman under Republic Act 8551, because the provision of Republic Act 8551 is very broad. As long as a person finished baccalaureate degree, then he is qualified to enter the PNP. This provision of law is one of the most controversial provisions that we are facing at present. Why? Because there was a proposal, a proposal qualifying the graduates of K-12 to enter the PNP. If I'm not mistaken, it is authored by Grace Poe, if I'm not mistaken. So What if that proposal eventually become a bill and eventually become a law, will be enforced? Then we will be going back way back 1966. Because if you remember the Police Act of 1966, the qualification of a person to become a policeman is at least high school graduate. Bumalik na tayo doon. Way back 1977, there was a move in order to professionalize the PNP or the police force. And way back 1998, there was Republic Act 8551, which actually enforced the professionalization of the police force. But the police force was not yet professionalized way back 1998. To tell you, there is still a special law that was Republic Act 9708 that followed up the enforcement of Republic Act 8551. Because according to 8551, a policeman who did not finish college is given specific years in order to finish his college. But instead of finishing their college degrees, they are just asking for extension and extension and extension until such time that Republic Act 9708 was there. So according to Republic Act 9708, the policeman who did not finish their degree courses must finish their college courses within 5 years from the effectivity of Republic Act 9708, and that is in the year of 2009. So let's go to as a qualification to become a chief of police. Under Republic Act 8551, there are only 3 professions who are qualified to become chief of police. So first is he must be a lawyer. Second, a licensed criminologist. And third is a graduate of Philippine National Police Academy. So these are the three professions who may qualify a person to become chief of police in a city or municipality. As prioritized course under the Republic Act 9708, as I told you a while ago, way back 1998, we have Republic Act 8551. According to Republic Act 8551, the policemen who did not finish their college, they are given specific years to finish their college. But the problem is they are not exerting an effort to finish their college. They are just asking for extension. Way back 2009, the Congress passed Republic Act 9708 saying that there is no more extension. You policemen who did not finish your college are given non-extendable 5 years in order to finish the same. Republic Act 9708 is a very, very short law. So it was enforced by virtue of an implementing rules and regulation. And under the implementing rules and regulation, the law enforcement related course that must be finished by policemen who are not yet degree course holders must be any of the following. First, Bachelor of Science in Criminology. Second, Bachelor of Arts in Political Science. And third, Bachelor of Science in Legal Management. So, in the history of criminology, there was a portion that was more or less 2003, wherein the top-notchers in the licensure examination are allowed to enter the PNP and given the initial rank of police inspector. But this application was of very short duration. So, what is now the fact o katotohanan about our profession? Majority of those in the police force are criminologists. So, discipline in criminology profession is inherent, especially to criminology students. So I am asking the teachers of criminology and deans of criminology, especially those who are taking up their mastorals at PUNP, for them to discipline their students without fear. That is because our students later on will become policemen, wherein they will be holding a firearm that can kill anyone. And as we have witnessed in the past incidents, the policemen are using it not against criminals, but against any persons for their personal gain. So I repeat, we must have the political will in order to discipline our students. So do not afraid, because we are supported by some Supreme Court decisions. There was a case wherein the students conducted rally inside the school. They disrupted the classes inside the school. So the school imposed a penalty of exclusion to these students. According to the school, you are no longer allowed to enroll next semester. So the students complained, saying that, why is it that you are removing us, Mabini colleges? We are only involved in expression of speech and expression. We are only exercising our right of speech and expression. So that cannot become a basis for us to be removed in this school. But according to the school, you have the constitutional rights of speech and expression, but we have also the constitutional rights of academic freedom to select who will be our students. And we excluded you in the list of our students, so it is our academic freedom. In other words, there are two constitutional rights that are conflicting here. The right of speech and expression of the students and the academic freedom of the college or the school. To cut this story short, the main issue in this case is, may a school administration, Mabini College, impose the student the penalty of exclusion. Ano ang sabi ng Supreme Court? Yes. Mabini School College or Mabini College Incorporated, they are allowed to exclude those students as a form of their academic freedom. In other words, if there is a conflict, this shows that if there is a conflict between right of speech and expression of the students and the academic freedom of the school, the academic freedom of the school will prevail. So let's go to the different laws in relation to criminology. We are discussing Republic Act 11131. It is the act regulating the practice of criminology profession in the Philippines that was approved way back November 2018, and we compared it to Republic Act 6506, the law that created the Board of Examiners of Criminologists. Republic Act 7722, the one that created the Commission on Higher Education. Republic Act 8981, that modernized the PRC, but the PRC was established by Presidential Decree 223. We have Republic Act 10912, which established the CPD law, or the Continuing professional development. So, what are the relationship, or what is the relationship among CHED, PRC, PRB for criminology, and the CPD Council to our profession? So we are going to discuss them one by one. As I told you a while back, CHED was created by Republic Act 7722. So the main provision or the coverage of CHED is both the public and private schools. Kaya hindi pwedeng sabihin ng state universities na CHED has no authority to us. They cannot say that. Why? Because it is very clear under the provisions of Republic Act 7722 that the CHED has the authority not only in private institutions but also to public institutions. We are talking about the state universities and colleges. So the CHED is setting minimum standards for programs and institutions of higher learning recommended by panel of experts. So the CHED, in other words, the CHED is the one that is creating or that is crafting the standards for a specific course through the panel of experts coming from that course. Once that the standards will be approved, they will be called CMOs. Okay, CMOs. CMO means CHED Memorandum Order. So in our criminology profession, we have CMO number 21 series of 2005, the one that established the CCGE. And we have the CMO 48 series of 2006, the one that will be governing our application to COEs and CODs. I'm very sure that Pan Pacific University will be applying soon in its Center of Development or Center of Excellence. We have the CHED Memorandum Order number 37, series of 2010, that will govern or that will serve as our guideline in OGT practicum. And the last CHED Memorandum Order that was issued with respect to criminology is the CHED Memorandum Order number 5, series of 2018. So that is the relationship. That is the relationship of CHED to us. How about the relationship of PRC to criminology? So the main function of the PRC is to administer and conduct licensure examination in the various regulatory boards. So when can we say that a profession is regulated by PRC? If it has a licensure examination. Not all courses have licensure examination. Because of this, the courses with no licensure examination, the PRC has no authority over them. Like, for example, the computer courses that have no licensure examination, the PRC have no authority over them. The PRC have authority over the criminology course because we have a licensure examination. And in every profession that is regulated, in every profession that has licensure examination, the PRC is creating a PRB for that purpose. So we have the PRB, or the Professional Regulatory Board for Criminology. For teachers, they have the Professional Regulatory Board for Teachers and others. So if I'm not mistaken, there are more than 50, perhaps about 50, 51, 52, 53 regulated courses in the Philippines. In other words, there are more or less 50 PRBs in the Philippines. So, at present, the Professional Regulatory Board for Criminologists has a chairperson by the name of Attorney Ramil Gabao, the former Dean of PCCR, and he has two members or commissioners by the name of Dr. Ruben Santa Teresa and Dr. George Fernandez. So what are the powers of the PRB? So the PRB for criminology will, of course, administer the licensure examination because they are tasked by PRC to do so. And next is they have the authority to monitor. So in one occasion, the commissioners of PRC came here in our school for them to conduct inspection in our school. So you may ask, what is the distinction between the inspection conducted by CHED and the inspection conducted by the Professional Regulatory Board? So it has a very, very great difference. The inspection being conducted by CHED is a little bit complicated. If I'm not mistaken, the checklist that we are using is consistent of 8 pages, more or less 8 pages checklist. But the checklist being used by PRC is consisted only of 2 pages, wherein the concentration of the inspection of PRC or PRB for criminology is only to determine if the license of the deans, chairperson, and faculty members are updated. Let's go to CPD. By the way, we have no so much concern in relation to this CPD because majority of our listeners are not yet licensed. But to give you an idea, if you will be passing the licensure examination, you will be applying for your license. And once that the date of validity of that license will lapse, then you will be applying for renewal. So is there a need for you to have CPD for, is there a need for you to complete the 45 unit CPD units before the renewal of your ID for the first time? To tell you no. You are only required to present a proof of the completion of the 45 CPD units if you are going to renew your license for the second time. No? So as I told you a while back, the person who will be renewing his license must, for the criminology profession, must complete 45 CPD units. Let's go to curriculum, syllabi, table of specifications. Our discussion is more on curriculum, not so much in syllabi and table of specifications. So our curriculum, especially the graduating criminology students, your curriculum is governed by CHED Memorandum Order Number 21, Series of 2005. Those who have entered the college after finishing K-12, their curriculum is governed by CHED Memorandum Order Number 5, Series of 2018. So you have different curriculums from the graduates of K-12. What are now the distinctions between the curriculum is stated in CHED Memorandum Order Number 21, Series of 2005, and that provided under CHED Memorandum Order Number 5, Series of 2018. And so these are the distinctions. My only concern is if you are using cell phones, perhaps the letters are not that clear. So let's go to the area of criminal law and jurisprudence. As you observe, in the area of criminal law and jurisprudence, the subjects criminal procedure and court testimony was merged as one subject only, that is CLG 6, under CMO 5 series of 2018. So you may ask, there are two subjects of, there are two law subjects under CMO 21 that was merged by CMO 5. But why is it that the original 5 subjects under criminal law and jurisprudence became 6 in Shared Memorandum Order number 5, series of 2018? That is because of the inclusion of the two subjects, namely, Introduction to Philippine Criminal Justice System. The Philippine Criminal Justice System is a social or criminal sociology subject under the CMO 21 series of 2005, but it was classified as law subject at present. And also the inclusion of the new subject, human rights education. So because of this, the original 5 subjects under the criminal law and jurisprudence became 6 in CMO 5 series of 2018. Next is with respect to LEA subject, to the law enforcement administration. So what is the modification or the distinction between CMO 21 and CMO 5? So first is, as you observe, in CMO 5 series of 2018, police patrol, the subject police patrol was deleted. So police patrol is LEA 3 under CMO 21, but under CMO 5, it was deleted. Next is with respect to the subject LEA 1. The LEA 1 under CMO 21 series of 2005, the descriptive title of which is Police Organization and Administration with Police Planning. But under the LEA 1 and in CMO 5 series of 2018, it became Law Enforcement Organization and Administration. From 3 units, it became 4 units. What is now the substantial distinction between LEA 1 in the old curriculum and the LEA 1 under the new curriculum? To tell you, there is no so much substantial distinction. It only happened that the discussions in LEA 1 under CMO 5 was expanded to include the other law enforcement agencies like PDEA and NBI. So in CMO 5 series of 2018, it introduced a new subject known as Law Enforcement Operations and Planning with Crime Mapping. Okay, so this is a new subject in LEA. With respect to criminalistic subjects, so in criminalistic subjects, CMO 5 series of 2018 reshuffled the presentation or the arrangement of the criminalistic subjects. Like for example, the personal identification under criminalistic 1 became forensic 2 in the CMO 5 series of 2018. And next major thing that was introduced by CMO 5 series of 2018 was it expressly classified the subject chemistry and toxicology as a major subject. To tell you, under CMO 21 series of 2005, forensic chemistry and toxicology is chemistry 2. It is a minor subject. But under the new law, that is CMO 5 series of 2018, it is already a major subject. And another thing that was introduced by CMO 5 was it changed the course code. From criminalistics, it became forensic. And even the units, generally, the criminalistic subjects has, every criminalistic subject before has 4 units each, but under the new law, it became 3 units already. And another thing was the subject legal medicine under CMO 21 series of 2005 was deleted. Also, the legal medicine was incorporated in the crime detection and investigation, which is the new slide. So, in crime detection and investigation, maliit, ano? Pasensya na, medyo maliit ang letters natin. But I cannot cut this into 2 tables. So, in the CMO 21 series of 2005, if you are going to observe, it has only 6 subjects. Okay, it has only 6 subjects under it. But why is it that in CMO 5 series of 2018 it became 9? That is because there are several subjects that were included. Okay, so first is of the subjects that are not present in CMO 21 but present in CMO 5. The first is specialized crime investigation 1 with legal medicine. We have no subject as like this before. It only happened that legal medicine is a 3-unit subject in the original criminalistic when it was still in the criminalistic area. Another subject that was introduced for the first time is the specialized crime investigation 2 with simulation on interrogation and interview. And the third subject that was included was the subject introduction to cybercrime and environmental laws and protection. The problem with this introduction to cybercrime and environmental laws and protection, CDI 9, it can still be splitted into 2. So some of the schools splitted this. Okay, in our school we separated those 2 into different separate and distinct subjects. One is introduction to cybercrime, which is CDI 9, a 3-unit subject, and another is environmental laws and protection, which is another 3-unit subject. With respect to criminal sociology, originally we have 6 subjects under crim social, but at present we have 8. So why is it that from the original 6 we had 8 at present under criminal sociology? So that is because of the introduction of the following subjects that are not present under CMO 21. What are these? First, theories of crime causation. Before, the theories in relation to criminology are incorporated in introduction to criminology. Okay, that was before. But at present, the theories was separated as a separate subject. And another subject that was introduced for the first time was dispute resolution and crisis management. That is criminology 6 with 3-unit credit. And the third subject that was incorporated is criminological research 2. That is criminology 8. So you may ask, of the original 6 subjects plus 3, they must be 9. Why is it that only 8 of them are present in CM05 series of 2018? That is because the subject Philippine criminal justice system was removed and it was transferred to the area of criminal law and jurisprudence. And the last area, pasensya na, medyo maingay kasi under construction ang nasa tabi namin. No? The basketball court of TSU Lucinda campus is under construction. So in criminology, in criminal sociology, from 6 we have 8, and in correctional administration, from 2 subjects it became 3. That is because of the inclusion of therapeutic modality, which is a 2-unit subject. Okay, so those are the distinctions between CHED Memorandum Order number 21, series of 2005, and CHED Memorandum Order number 5, series of 2018. So I kept on telling our reviewees for them to pass the licensure examination now. They must not wait for the products of K-12 for them to take the licensure examination with them, because there are several subjects that were already included. Okay? With respect to syllabi, our syllabi is being inspected by CHED. So there is a specific checklist for that purpose. So before the CHED Memorandum Order number 5, series of 2018, there is no problem with our syllabi, because CHED Memorandum Order number 21, series of 2005, already provided for a sample syllabi. Our problem perhaps is with respect to CHED Memorandum Order number 5, series of 2018, because there is no syllabi attached to it. So you may ask, who has the authority to execute their own syllabi? Theoretically speaking, it is the PRB for criminology who must be executing our syllabi, because that is what is provided under section 10 paragraph G of Republic Act 11131, which provides that the PRB for criminologists shall promulgate, adapt, or amend syllabi and table of specifications. It only happened that there is no syllabi presented yet by the PRB. So, but there was an effort. There was an effort of the PRB for us to have our syllabi, and I don't know if the Pan Pacific University was represented during the syllabi making at Midas Hotel way back April 2018. I don't know if they are represented. OSHAS, if I don't know also if you are represented during that time, but only one thing is certain. There was a syllabi making before, and it is a little bit successful. It only happened that there are some subjects that are not yet completed. So it is now the job of the dean to, because there is no complete syllabi that we have in national level, then it is now the inherent duty of the dean of CCGE or the chairperson of criminology to ensure that the students will be provided with complete syllabi. With respect to table of specifications, okay, so I'm very thankful that we have beaten the time. No? With respect to table of specifications, the table of specifications is not being checked during CHED or PRC visitation. The only being checked during CHED visitation is the curriculum, the arrangement of curriculum and syllabi. But with respect to TOS, that is plainly in the discretion of the dean or administration if he is going to check for the TOS of the faculty members. Provided, however, that if a school is applying for an accreditation, he must present its own TOS or table of specification. You may ask, ano ba itong table of specification na ito? So, ang table of specification, in every question, like for example, question number 1, what is the revised penal code of the Philippines? So that is a multiple choice examination. Letter A, Act 3815. Letter B, Presidential Decree 3815. Letter C, Republic Act 3815. And D, none of the above. So if I were the teacher, I will be classifying that as easy. Okay, so that may be considered as an easy question. And we all know that that is remembering. Okay, so in other words, if there is a specific question to be given by a teacher, that will be classified by him or her if it is easy, moderate, or difficult. And another classification is that remembering, understanding, application, analysis, evaluating, creating, etc. And the table of specification also states for the distribution of question. So like for example, if you are going to teach criminal justice system, we all know that there are 5 pillars of the criminal justice system, and we may include preliminaries. So 6 division of discussions all in all. So the teacher may just state there that out of 100 questions, 50 came from preliminaries, and 10 came from law enforcement, 10 from prosecution, so on and so forth. So that is an example of distribution of questions. In the licensure examination, is there a table of specification also? To tell you yes. In the licensure examination, you may be surprised if you will be encountering the table of specification. Sampulan natin. In the area of criminal law and jurisprudence, there are several subjects under it. Kaya pwedeng sabihin the PRC may make now the distribution of questions. Perhaps sample distribution. Criminal law 1, we will be getting 30 questions. Criminal law 2, another 30 questions. So on and so forth. Okay, that is an example of distribution of questions. If you will be encountering the table of specification in the licensure examination, just read it and have an idea over it, but do not take it very seriously. Why? Because in the history, did the PRC follow the table of specifications during the licensure examination? To tell you, no comment. That is the safest answer. No comment. Because as long as I remember, when I became a review director, I observed that the table of specification was not being followed. But who knows? In the future, they are now going to follow the same, especially in the distribution of questions. So, as I told you a while back, there are several facts in relation to curriculum, syllabi, and TOS. So the curriculum and syllabi, they are being checked, but TOS is not. And as I told you a while back, the syllabi under CMO 21 series of 2005 was already attached in it, but still the teacher has the authority to enrich said syllabi. So we will now be going to the penal clause or the penal provisions of Republic Act 11131. So what are the prohibited acts under Republic Act 11131? So first is practicing criminology without valid certificate. So ibig sabihin, hindi siya lisensyado, but he is practicing criminology. Paano kung ang teacher ninyo ay may license siya but nag-lapse at hindi siya nag-renew? Can he be held liable for this crime? To tell you no. Ordinarily, what we are doing is, if there is a teacher with expired license, what we are telling the teacher is for him to renew the same. Okay, for the teacher to renew the same. And generally, he is given 30 days to renew his license. Okay, letter C is very important because there are several persons who are committing this. Criminologists who are abetting the illegal practice of non-criminologists. I am not naming directly a review center, but there are some review centers not owned by non-criminologists. Okay? Review centers, the review director is not criminologist. So how come that they are being operating as such? That is because there are some criminologists who are abetting their illegal practice. Example, but I encountered a review director, non-criminologist, who authored criminology books. Tapos nakalagay doon sa criminology books, ang kanyang researchers ay criminologists. So, yung mga criminologists na nag-act na researcher, binigay nila ang research nila sa non-criminologist, tapos pinalabas nila ng author yung non-criminologist, to tell you, pwede silang kasuhan ng abetting the illegal practice of criminology. Okay, that is a crime. Oh, that is a crime. So, if you are a criminologist employed by a review center owned by a non-criminologist, and you are offering review in criminology, it is better for you to establish your own criminology review center instead of adhering with those persons. So next is violations of the implementing rules and regulations of Republic Act 11131. And next, thank you. Thank you na pala. So I am very